What's up everyone, welcome back to our page, and this video we will be talking about the certificate for an ordinary share in a business or a company. There has been uncertainty in practice with regard to the transitional status and treatment of shares under the Companies Act, with a number of questions being raised in this regard. Now, to issue any shares, a company must first ensure that its Memorandum of Incorporation sets out the classes of shares and the number of shares of each class that a company is authorized to issue. In addition, in respect of each class of share, the Memorandum of Incorporation of a company must set out the preferences, rights, limitations, and other terms associated with a class of shares. Now, the number of authorized shares of each class and the preferences, rights, limitations, and other terms associated with a class of shares may only be changed by an amendment of the Memorandum of Incorporation by a resolution of the board of the company, who may increase or decrease the number of authorized shares of any class or reclassify any classified shares. That is, amend the terms attached to such shares and that have been authorized but not issued unless the memorandum provides for a different approval process, and may only be changed by way of a special resolution if any of the shares in a specific class have already been issued. Now, it is important to note that whereas the general practice under the Companies Act of 1973 was to reflect the terms of certain classes of shares in subscription agreements or other documents separate from the old articles of association, especially when issuing preference shares for funding purposes. The Company Act now requires that all preferences, rights, limitations, and other terms associated with a class of shares must be contained in the Memorandum of Incorporation, failing which they may not be enforceable. Now, it is also critical to ensure that the terms of the same class of shares are indeed the same. For example, if a company issues shares to its shareholders of the same class, say ordinary shares, but provides in the Memorandum of Incorporation or shareholders agreements that one shareholder will have more than one voting right or will have more voting rights than other shareholders or greater rights as regards dividends, notwithstanding equal shareholding, the shareholders in fact hold different classes of shares, and the company is required under the Companies Act to name the classes of shares differently. Share certificates are sent out when shares are granted and made available to new shareholders at the time of incorporation and or after incorporation, or when ownership of existing shares is transferred from one individual to another after company formation. Shareholders are required to receive a share certificate right after they buy at least one share. A copy of all issued share certificates must be kept by businesses for their records. 𝗪𝗔 does not keep record of the shareholders, neither the issued shares. Therefore, share certificates must be drawn up by the company itself, although such is not mandatory in terms of the Companies Act of 2008. Now, a share certificate validates that on a specific date a person is the certified share owner in a company. With regards to the Companies Act of 2006, it is deemed prima facie evidence, enough evidence, that's what I mean, except the contrary is publicized in Scotland, of the member share ownership in the company. On the other hand, whilst a share certificate may be given a company or given by a company, it is a pass in the members register that offers legal confirmation of share rights in the company whenever trending with share certificates. Thus, it is essential to also refer to the members register to ensure the two are reliable. What are the information details that are shown on a share certificate? The information that ought to be added as part of a share certificate template includes the name and registered number of the company, a distinct certificate number, and listed office address of the company, a shareholder's name, the share class or type of the shareholder, the shareholder's address, quantity of shares the share certificate covered, the degree to which the shares are paid up. Normally, shares are always fully paid. Now, the ideal share certificate template should always provide for what I'm going to discuss now. Firstly, a share certificate needs to be signed by two companies' directors or a director and the company's secretary, or in the event that the company has no company secretary but a single director, then the company director in the presence of an eyewitness who confirms the director's signature. Every share certificate must be dated on the issuing of a share. Now, when should a share certificate then be issued? Subject to any condition of or to the contrary in the company's article of association, there exists a legal time limit for allotting a share certificate. After your primary enlistment, company share certificates should be issued to subscribers within 2 months. Generally, that is carried out as part of the first board meeting. Thereafter, a company has to, within 2 months of share issuance, allot the share certificate that represents those shares. The same 2-month time limit applies subsequent to any share transfer. Even though share certificates needs to be issued to the enlisted holder, you are not under any condition to forward a copy of the share certificate to the 𝗪𝗔𝗶. Any other rules for allotting such share certificates are that, just like with other areas of company management prior to the issuing of share certificates, it is important to check the company's Memorandum of Incorporation. The benchmark practice is for any business to allot a single share certificate. In respect of all shares allotted at a specific time, even though a shareholder can ask for a split share certificate, the other major case where above one share certificate will be necessary is when share certificates represent holdings in more than one share class. Now, even though they are owned by the same shareholder, you'll have to issue a different share certificate for the shares in every class. Now, for a mutual shareholding, whilst it is good to add the name to every individual holder on the certificate, only the address of the initial named holder must be shown. In addition, you only need to allot a share certificate for a mutual shareholding, with the certificate forwarded to the initial named subscriber instead of a separate certificate to every mutual shareholder. A typical share certificate is a rectangular document set out in landscape orientation. It states the date of the issue and all relevant details that pertain to the shares that have been taken on a certain date by a particular shareholder. Share certificates can be issued in electronic format as a PDF file. However, several individuals prefer to receive a traditional printed certificate. Both formats can be requested upon company formation, and if a shareholder loses their share certificate or it is significantly damaged, the company can grant another. Damaged certificates must be returned to the company to be destroyed, and in large companies, the shareholder may be required to prove his or her identity before receiving a replacement certificate. Except to the extent that a company's Memorandum of Incorporation provides otherwise, directors are authorized to issue the share of a company provided that the shares issued have been authorized by or in terms of a company's Memorandum of Incorporation, and such shares are within the classes authorized and adequate consideration is received by the company for such shares. Generally speaking, issuing shares in a company is a simple process in that all that is required is for the directors to pass a resolution authorizing the company to issue the shares to a particular individual or a juristic person, subject, of course, to specific requirements in the Memorandum of Incorporation or the Shareholders' Agreement. Now, this is different from the old 1973 Company Act, because as the old Act always required a shareholders' resolution for the issue of additional shares to protect shareholders against dilution, the Companies Act of 2008 now only requires the approval of shareholders by special resolution in exceptional circumstances, namely where a company intends on issuing shares to a director or proscribed officer of that company, or a person related or interrelated to that company, or a director or prescribed officer, or if the shares to be issued will constitute 30% or more of the voting rights in that specific class, a special resolution will also be required. Now, minority shareholders may therefore wish to negotiate better protection with regard to the issue of shares in the Memorandum of Incorporation to prevent the board from diluting the minority without having to seek the minority's approval. That is it for the certificate of ordinary shares in today's video. If you guys enjoyed this video, please like and subscribe to our YouTube channel. Click on the bell button for post notification for more videos like this. If you guys would like to see what a certificate for ordinary share actually looks like, you can visit our website www.lawyers.easyfind.co.za. And please do follow us on Facebook and Instagram for more videos like this. And that's it, guys. Stay tuned for the next video.